Buongiorno a tutti. Good morning, everyone. My name is Federica Ferrieri, and I'm the Honorary Consul here in Northern Ireland. So I'm very happy today to introduce the guests and the speakers that we have. First of all, I would like to introduce Fabio Monaco. Fabio is our Consul General in Edinburgh, and I would like to thank him very, very much for being so present in the life of the Italian community here in Northern Ireland, and to thank all the staff at the Consulate General for their assistance. Fabio, prego.
Buongiorno, good morning to you all, and thanks to participate to this webinar that I hope will be followed by others. Just few words from my side. The Italian Consulate, together with the other Italian institutions in Scotland, Northern Ireland, but also with other associations, has been trying to help our national to cope with the problem related to the COVID-19 emergency since March. And since the situation is going probably to last for a while, if I can say that, now we want to support those who live here by informing them about the measures put in place by the local authorities. Let me thank all the speakers to join us today, and of course all the other partners, Federica, Lumturi, Davide, and Adriano, who made this possible. From my side, I have a final warning to send. Do not forget the EU settlement status scheme. Please keep sending your application and don't wait. Thanks again.
So now, thank you very much, Fabio. I would like to introduce now Adriano De Marco, who's the president of our Comites. The Comites is the Comitato degli Italiani all'Estero for Scotland and Northern Ireland. So thank you, Adriano, and thank to Davide Bargna, who's here today, and also Carlo Pirozzi, who is with us today, again from the Comites, for organizing this initiative in support of the community here in Northern Ireland. And I'm very, very grateful because a webinar has been organized for Scotland, but we have really our separate one to be able to assist people living here even better. So Adriano, prego.
Sì, buongiorno a tutti, good morning to everyone. On behalf of the member of the Comites, I would like to say thanks you to all speakers taking part today. A special thanks to our Consul General Fabio Monaco for his full cooperation of this event. Also to Federica, Honorary Consul of Northern Ireland, for our commitment to the community always. Also, I would like to thank you to Carlo Pirozzi and Davide Bargna for their hard work and making this event possible. I wish everybody well, and all will be a good meeting. Thank you very much.
Grazie, Adriano. Thank you very much. And now I would like to introduce Davide Bargna, who is part of the Comites, but is also the project manager and Scottish branch representative at the Italian Chamber of Commerce, based in Edinburgh, Davide. Am I right?
Yes.
So I would like to thank you very much for very successfully coordinating this initiative and for finally making it happen today. Prego, Davide.
Thank you very much, Federica. As mentioned, I'm the representative of the Italian Chamber of Commerce in Scotland, and we cover Northern Ireland as well. I don't want to take too much time away from the panelists, as it is the main focus. I just want to mention that the Italian Chamber of Commerce for the UK is here to support any Italian companies or entrepreneurs that is interested in making business in Scotland or Northern Ireland. Of course, at the moment, our activities are reduced in numbers due to the coronavirus emergency, but we are still supporting our members, and I would say the Italian business community generally speaking, in order to understand how the government could support their business at the moment, and through, of course, these sort of webinars disseminating information and details about that. So I'm very happy to be supporting the Comites and the Italian Consulate today in order to support the community in Northern Ireland. And yeah, I hope this webinar will be helpful and enjoy. Thank you very much again.
Grazie mille, Davide. So it's the moment now of today's experts. So what happens now is we'll have a short presentation for each field. Every expert will talk about their own field. And at the end, we'll have a Q&A session. So during the speeches, I would like everybody who's got a question to just type it in the chat. So during the presentations, you know, you get your ideas, you type your questions, and then we will select, if there are too many, we will select the most significant, maybe the most frequently asked, and so on. And in the final Q&A session, you'll be able to ask them and to get your answers. So I would like to start with Lumturi Podrimaj. I'm not sure, Lumturi, I've never attempted to pronounce your surname. So anyway, Lumturi is the EUSS project manager at Advice and I. Advice and I is a local charity that offers free and impartial advice to any person here in Northern Ireland in a variety really of matters. So I would like to thank Advice and I, and Lumturi in particular, and Fiona McGee as well, who's the Deputy CEO, for a very successful collaboration in the past few months regarding the settlement scheme. Because Advice and I has provided and continue to provide the Italian community here in Northern Ireland with great support about the pre-settled as well as the settled status. So Lumturi, your turn, there you go.
Okay. Thank you, Federica. Good morning, everyone. And on behalf of Advice and I really would like to thank you all for your help with the EUSS project and the community, helping the community here. Federica has done excellent work, not only for Italian community only, but also for other EU nationals. She has initiated some big projects in Northern Ireland, and we are looking forward to that, to continuity of that work. I will share, I have a presentation to share with you. Let's see if this is working now, sorry. Oh. Okay. So basically, I will be talking about the EUSS, and this is a scheme that's been introduced by the government here for EU nationals on securing their status after UK exits the EU. I will be talking about what you would get, what kind of status you get, and what you need to do to get the status. And also I'll be focusing on COVID-19 impacts, and then give you some information of where you get the information and support. And I am also really looking forward to the questions from the group. Definitely I look forward to the future working if anyone needs help after we leave here. So we won't be able to tell how many people have actually applied from the group, but it would be nice to hear from anybody who hasn't applied yet for the EUSS. Okay, so we are, with applying for your status, you are really protecting your rights, and that means that your rights that you have now in the UK will be protected in the future. Now, Advice and I is a member organization that has about 70 members, and they're all advice-giving organizations. And we give advice on different areas, on tax and benefits, on money and debt, and that is personal debt and business debt, on welfare rights, and also we are at the moment the leading COVID-19 helpline. So if you ever need any other services, please contact us. We have the website, and I'll share the details at the end of it, of the slides. We are, with regards to EU settlement scheme, we are registered OISC. This is the Office of Immigration Service Commissioner that regulates immigration advice given in the UK. So you're getting advice from people who are registered and qualified to do it. Okay, so okay, so I just want also to remind people about the dates and the deadlines. So if you really plan to continue living, working, and studying in the UK after June 30th next year, you will have to secure your documentation via EU settlement scheme, which has been officially opened since 30th of March last year. And the deadline for the application is, as I said earlier, 30th of June. And please make sure you apply before that. We are really advising people to apply before 31st of December, when free movement ends, because simply in case you have any problems with the application, before that you can just reapply, but after that you will have to appeal. So please make sure you remember this date, 31st of December, if possible, and if you have the documents and everything else that's required, try and make the application before that date. So if you apply for status at the moment, the Home Office is looking only for you to prove the residence. So based on, they're not looking if you have been working here or if you've been getting benefits or anything like that. But if you have lived here for less than 5 years, you will be getting a pre-settled status, which is limited leave to remain, and that expires. So make sure that before that status expires, you make the application for the settled status. It doesn't happen automatically, so you have to make sure that you apply before that status ends. Yeah. And if you have excuse me, if you've already been here for living continuously for 5 years, you will get settled status, and that allows you to continue living here legally. It is like indefinite leave to remain, and it also gives you, if you're planning to apply for British citizenship, you'll have to hold it for 1 year before you apply for citizenship, but you also have to meet other criteria for citizenship. And the other thing, this status gives you the right to go away out of the UK for 5 years without compromising your status, but you have to make sure that you come back before that 5-year ends, so you don't lose this status. So what is the process? The process is it's an online application for most of people, but there is paper applications for others, and that is for non-EU nationals. But for EU nationals that have biometric or even non-biometric documents, they make the application online. It's meant to be digital and user-friendly, but it might be difficult if you don't speak the language and if you can't use different smartphones or computer. But you also have to be able to scan documents, because that is the part of the application. Once you make the application, you'll get the certificate of application generated on digital format. So you will not be getting letters or cards. You will only get an email and attachment to it. The good thing is there's no fee for this. As I mentioned earlier, if you have to reapply before end of December, you reapply for free. So it's better, you know, like to try it before then. We do help. We help with all of the above. So if you have problems with using the smartphones or computer, we can support you over the phone at the moment, but hopefully if COVID, if the situation improves, we can go back to face-to-face. I'll brief you more on that one, but please contact us. There's a free phone number there. which I'll share again at the end of the presentation, and the email address. So what are the key steps for you for making the application? You are expected to prove your identity and nationality, and you do that with valid passport or national ID card. So you have to make sure that your passport is valid. That is one of the reasons that some of people from different communities that contact us, they can't make the application because they do not have a valid passport. And unfortunately, most of people are waiting to go back home during the summer to do it. And some other, it depends from what country you come from. For others, it's possible to do it here or somewhere in the UK. But so that is one of the requirements. Do not post or make the application with an invalid document because it will be refused. The other thing is that you're required to do is proof of residence. You do that with national insurance number, but if there was breaks during your time here, say you didn't work for a period of time or you didn't get benefits, you will be required to provide further evidence for that, and Home Office should contact you for that evidence before they make a decision. The other thing is, which is quite important, is disclosing criminal convictions. So if you're over 18, you are required to disclose your any convictions that you may have committed in the past. Now, I'll go in more detail about that in the next slide, but just these are the 3 key steps at this stage that you need to think about the application and what is required. So if you try and think putting these things together before you start making the application. I mentioned there for continuous residence, so for anybody to get the settled status here, they're required to have been here living continuously, and that is you must not have, you know, for all the 5 years or for every 12 months, you mustn't have been absent from the UK for more than 6 months. Now, one absence of more than 6 months is allowed, but it should not have exceeded 12 months, and that's only permitted for serious situations, say, for example, and important reasons, say you had a childbirth or you had a serious illness, you were away when that happened, or you were studying, or vocational training and overseas posting, that's through work, but also people's military service that is allowed. For example, if you get these now, and as I said, in 5 years, then you apply for settled status, you have to make sure that you maintain this continuous residence. So for every year, you're not away, for every 12 months, you're not out of the country for more than 6 months. So something you need to remember. So with regards to criminality check, this has been putting people away from making the application, and that's why I thought I'd mention this one here. And the Home Office will carry out criminality checks to identify serious or persistent offenders or anyone who possesses a threat to the country. I'll emphasize again, this is for serious and persistent offenders. So that it has to be very serious. So we're looking for cases that have been in prison for more than 12 months and things like that. But whatever criminality activity, or if you've been criminally convicted, please, you make sure you disclose that that information on the application, and that is you are not required on the application to disclose anything in the last 12 months, but you're required to disclose any criminality here or outside UK, and they will then check all that information against their databases in the UK and overseas. Now, sometimes people might have small convictions and are concerned about it, and they might not apply at all. In situations when you're not sure, please contact us, because we can advise you on this, and we can also put you in touch with organizations that offer higher tier of immigration advice and deal with these issues. So yes, if you're concerned and you are not sure, you're not confident with regards to this, please contact us as soon as possible. Don't let this put you away. So families, applications for families are considered, if they're put together, then they are considered at the same time, but each individual family member has to make the application themselves separately. And EU family members of EU citizens, they do not need to provide evidence of their relationship. But if they are non-EU family members, they do need to provide evidence of the family relationship, say marriage certificate, or the identity documents, the evidence for a EU citizen. And again, with permanent residence, some people might have permanent residence, and that is something that confuses people. They think that, you know, if they have permanent residence, they don't need to apply. Yes, you do need to apply with, even if you have permanent residence. And with this is a very quick application, because all you have to do is basically confirm that you haven't been absent from the UK in the last 5 years, and then they will still, you still need to declare any criminality, any convictions, so they will be checking that one. Okay, so if you are refused, what to do if you're refused? You can either contact your EUSS advisor as soon as possible, but as I mentioned earlier, you can reapply as many times before, if you're refused before 31st of December. But after that, then it's appeals. Okay, some of the top tips for pre-settled status. If you get pre-settled status, after 5 years you apply for settled status, and you will meet that if you maintain your continuous residence, and then you will, during that time, you will be eligible to access work or NHS, school, education, and you'll be able to travel in and out of the UK, and any child born in the UK during that time, when you have pre-settled status, will automatically get pre-settled status. And then for settled status, if you secure your settled status, you can be away. I'm repeating myself, but just making sure you get this information. And then, so you can be absent for up to 5 years without losing your status. You may be eligible to applying for British citizenship after 1 year, provided that you meet the other criteria. And then you can access NHS, public funds, benefits and pensions, that is if you're eligible. And any child born to a parent who has settled status, they will be automatically British. With the status, you can also bring your family members and extended family members. But after the transition period ends, as long as the relationship with the family members was existing before 31st of December. Please, if I'm talking very quick, let me know, but also make notes of anything that if you don't understand me or anything like that, and then you can ask me at the end. Okay, there is another thing after you make these, after you get the status, is you really have to make sure that you inform the Home Office of any change of circumstances, and you need to report that. Usually what we do is if somebody comes through our services, when we close the case, when there is an outcome on the case, we send a letter out with different information, and one of it is a link which takes you to this site on the Home Office kind of section website where you can update any change of circumstances. So you would do that if you've changed your name, you've got married or something, if you've changed your nationality or you have changed your passport, or if you've changed your date of birth in case it was recorded somewhere incorrectly, or even your gender. So that is something that you need to update the Home Office in the future after you get the status. Now, this slide, I'm going to talk about COVID-19 impact. And as you know, most of face-to-face services have had to be suspended due to the government advice and the situation. And we are one of the services that have had to stop the face-to-face advice. Unfortunately, also other charities have closed, and scanning centers. So if you are non-EU national, family member of EU national, you're required to post your documents, and you're required to attend scanning centers for biometric appointments. These are all closed at the moment, and also actually the embassies and consulates, yes, you can talk about that, but we know that that is not happening either for people that need to renew their passports. With regards to Home Office, at the moment, they are still making decisions, but they are much more slower at the moment, simply because they have less staff in place. And that is it's to protect their staff. And to maintain the social distancing measures. They are not accepting documents via post, so please do not post anything. And that has, but if you really need to, if you're worried about the application that needs documents posted, you would need to contact them first. And if they request something, then that's when you post. But as it is, do not post anything. And so you can contact them via phone, but there is also an online contact form. If you're not confident with any of that, just contact us. At the moment, only online applications can be processed, and that is for people who have biometric passports, the biometric documents. So if the biometric document, you can tell it's biometric if it has that chip that you can scan. If you don't have biometric documents, you are not able to really make the application at this stage during COVID, because simply no documents can be posted. We are continuing to give advice and support via phone or email, so please contact us. It is possible for us, for anyone that has biometric ID and access to internet and digital devices, it is possible for us to take you step by step to make that application. So we have advisors doing this on a daily basis, helping people to make applications, even if they've never used these kind of applications before, or any kind of online applications before. But it's not possible, as I said again earlier, it's not possible to make this application if you don't have biometric document at this stage. Very unfortunate, but hopefully things will change. Okay, so and the final, this is a final slide. We really strongly and you apply for EU settlement status as soon as possible if you have documents in place, or if you have valid documents, and if you have access to digital means, contact us and we can help you go through that. And you can contact us via free phone, and that is 0800 138 6545. The other thing is that we would really like you to pass on the message and let other people know. So apply yourself as soon as possible if you have the documents that are required. Make sure that your family and friends apply, and inform any of your friends, other EU nationals, and this is a requirement. This is extremely important, because as I said, if you don't apply, there is going to be serious difficulties after 30th of January. You won't be really able to stay here. Yes, so let me see. That's me. Thank you for your attention. Okay.
Lumturi, thank you very, very much for this very detailed presentation. I know we've received several questions for you so far, so we can answer them at the end. And in the meantime, I would like to introduce Ryan Fitzsimmons, who is the Training and Development Practitioner, again, at Advice NI. So I'm very happy to have Ryan on board today, because he's an expert really in the field of general benefits, employment benefits, housing benefits, and also housing rights. And in this very challenging moment, these are all subjects that regard our community very closely. So I'm sure Ryan receives a high amount of questions every day about all these subjects and matters, and can certainly draw our attention to the most frequent questions and answers. It's your go, Ryan. There you go.
Good morning, and thank you. It's a pleasure to be here. I'm just going to very generally speak to common rights in social security and housing and employment. It's important to understand that people's individual entitlements will very much depend upon their own circumstances. So the invitation is there for anyone with questions today to ask them, but if there's something that you specifically need around advice, my advice services will be able to cater for that. But let's have a look at what we'll cover. So I'm going to explain the social security and tax credit system, particularly with an emphasis on EEA nationals. I'll explain general employment rights for people throughout the employment relationship. And I'll also explain some general housing rights in the UK. But most importantly, I'll explain where you can get help and advice on those rights and entitlements, so you can follow up as an individual and we can ensure you get absolutely the right advice. So we'll start with social security, not benefits. Advice NI's position is very strong. The word is social security, not benefits. It's social security because it's an entitlement. It's not a bonus. And that's what we're here to talk about today. We're here to talk about entitlements. The benefit system, as it's called, we call it the social security system, is complex. And an entitlement essentially depends on different factors for individuals. But in the United Kingdom, there are means-tested benefits, which tend to top up a low or zero income or salary. And there are non-means-tested benefits, which tend to be for disability or illness. Individuals can apply for these, couples can apply for these, parents can apply for these on behalf of their children. In the United Kingdom, the social security system pays modest amounts of money to people who are parents, to carers of disabled people, to disabled people themselves, to those who are working, and require help with rent, or to those who are not working and require a basic income, either whilst they look for more work, or if the situation doesn't allow work, support is also available long term. In recent years, though, the social security system in the United Kingdom has been streamlined. Many of our means-tested benefits for employment or sickness or for housing have been streamlined into one single benefit known as universal credit. Universal credit is a relatively new concept to UK law, and it can be quite a difficult challenge for those who are not used to receiving it or have never claimed it before. So again, we'll provide some numbers at the end of this, so that if you have specific questions about universal credit, you can get advice, but I'm happy to take questions at the end as well. Most importantly, and my colleague Lumturi discussed this earlier, important to understand that the right to benefit in the United Kingdom is still a European right. From a legal position, Brexit doesn't change anything with regards to social security entitlement. When social security entitlement law for EEA nationals was drafted, it used European law, but it was enshrined in domestic UK law. So unless there's any repeal of this, all of the rules that did apply to EEA nationals will continue to apply. The one difference, though, and it's a subtle difference, is with the introduction of the EU settlement scheme. If you have not yet applied for the settlement scheme, and you're not convinced by my colleague Lumturi's comments on why you should, let me add to that. When EE nationals apply for benefits, there's a test of about 9 different rights to reside. And it can be complex, and it can require decision makers to ask a lot of questions of individuals who apply. Straightforwardly, if you apply and receive your status through the EU settlement scheme, those questions don't need to be asked. Your settled status will ensure that you're able to apply for benefits and receive your entitlements accordingly. Now that's settled status. Pre-settled status doesn't provide automatic access to benefits, but other rights to reside might exist. For example, if you came here to work, if you are working, if you've lived here for a certain number of years, if you were self-sufficient and aren't, or you're a family member of any of the above, or a close relative, those rights may also still exist. But most importantly, in relation to social security entitlement, because it is so personal to individuals, training will never address an individual's advice needs. Our seminar, we warmly invite you to contact us at Advice NI, where we will provide you with advice ourselves, or we will introduce you to one of our 70 member organizations who are local in your community who will do just that. Also, for those of you who enjoy online learning and developing new skills, at the present time, Advice NI has a number of free training courses available in relation to access to universal credit and access to sickness benefits. And you're very welcome to join our website and look at these short seminars for free. Important to also mention that there have been some emergency changes to the delivery of social security due to the current COVID-19 crisis. We have a dedicated section on the Advice NI website which covers this, and you can find out how changes to the benefit system, if you're currently in receipt of social security, might impact you. For example, those in receipt of job seekers allowance currently and very sensibly don't have to look for work, nor do they have to report job seeking activity. People who are sick as a result of the coronavirus do not have to attend for medical certification and will receive benefits automatically. And other subtle changes that are part of government advice to protect people so that we do not continue to spread this virus. Secondly, we turn to employment rights. Employment rights are two-part. Your employer will have certain obligations to you based on a contract of employment, which means those are terms which you have arranged with your employer. But also, employers have certain statutory or legal rights that they have to fulfill. Employment law can be extremely complex and based entirely sometimes on contracts of employment, but try and think of your employment relationship at different stages throughout your career. On the very first day of a new job, you're protected from unfair dismissal in limited circumstances. You're also entitled to at least the national minimum wage. You're entitled to join a trade union. You're entitled as a group of employees to make a claim for union recognition to your employer, which means bringing in a union to your workplace if you don't already have one. You're also entitled to maternity leave or paid adoption leave. And most importantly, you're protected from discrimination on the grounds of sex, race, religion, belief, sexual orientation, marital or civil partnership status, age, or disability. On day one, no employer can discriminate. The myth is often you have no employment rights for at least a year, and it's simply not true. From day one, some very strong rights exist. During the first month of your new job, if your contract was terminated, you would be entitled to at least a week's notice. You would also be entitled to guarantee payments in case of lack of work. This is particularly significant with COVID-19, where employers have wound down businesses temporarily. You're also entitled to payment of salary during suspension on medical grounds if you're unfit for work and your employer removes you, and the right not to be dismissed on any medical grounds also. During the first 2 months, but it's best practice to have this up front, every employee is entitled to a written statement of the particulars of their employment. It is law that this must be received within 8 weeks. Those particulars will contain all of the entitlements that you have negotiated with your employer, not the statutory ones. So working hours, breaks, the specifics of your salary package, any perks, etc. Those will be contained within the particulars of employment. The reason this is law is because until the early 2000s, it wasn't an obligation of an employer to provide a statement or a contract of employment, so people were very unsure what their rights were. Since the legislation was introduced, everyone should be absolutely clear on what their employment rights are. And if they haven't received a document within 2 months, an employer is in very serious breach of employment law. During the first 6 months of a job, you'll be entitled to paid paternity leave, adoption pay, maternity pay, and you're able to apply for flexible working rights. So if you're a carer, if you have family obligations, you should be entitled to apply for alterations and reasonable adjustments to your working life to balance home and work. Then during the first and second year, during the first year, you're entitled to 5.6 weeks of paid annual leave if you work full-time. If you work part-time, they'll calculate that out on a pro rata basis. In year 2, if your employer terminates your employment through redundancy, you're entitled to 1 week's notice for each year you've worked. Redundancy payments and time off to look for other work, arrange training, or attend interviews if that has happened to you. Employment law is something that, for those of us who don't have a full understanding, it's very difficult to bring up disputes with your employer, particularly if you don't feel qualified to speak to it. We have a member organization called the Labour Relations Agency, who are funded by government to provide free and impartial employment advice to all employees and also to employers who find it difficult, perhaps small businesses who don't have a budget to hire a lawyer to explain what employment law is to them. So the Labour Relations Agency play a key part. They'll provide individual advice, they'll help employers, and in a situation where an employee has a dispute with an employer, they will also provide mediation services. And again, during COVID-19, there are some very subtle but very important changes to employment law, particularly around safety of work, statutory sick pay, and the various furlough and retention schemes available for those who currently can't work because their employers had to shut down. But again, Advice NI and any of our members and many of our own staff are fully qualified to give basic employment advice. And finally, some general housing rights. Importantly, EA nationals and those with settled status are entitled to apply for social housing. That is housing administered by our government, provided for from the public purse, where rents are set at a lower social economy level. Important to understand that social housing in Northern Ireland is in very short supply. On average, around 35,000 people are on the waiting list for social housing at any one time. And around 8,000 to 9,000 allocations a year are possible. So social housing is administered and awarded on a priority needs basis. For those who don't have accommodation, or it's not reasonable for them to remain in their home, or their housing conditions might cause injury or difficulties with their health. Later, we'll look at where you can get advice in relation to that. More commonly, in our experience, EA nationals who come here tend to rent privately. And it's important to understand that private rental sector rights in recent years favor the tenant more than they've ever had. And also assistance is available through the social security system if you have a low or no income to help with costs like rent. Owner-occupiers also have some housing rights in Northern Ireland. If you have a low or zero income, you can get help with your rates or help with mortgage interest if you find yourself out of work suddenly. And also, there are a number of home improvement and energy efficiency grants for those on low and moderate income to improve their homes. In recent years, the private rental sector in Northern Ireland has grown significantly. It used to account for about 7 or 8% of our housing stock. That's doubled in the last number of years. The main reason for that is the lack of availability of affordable housing to buy or no social housing. One of the difficulties with the expansion of the private rental sector is the idea that many landlords weren't providing tenants with the rights. So as the sector grew, more legislation was brought in to ensure tenants' rights. Landlords cannot refuse people from accessing rental properties because they're on benefits. That was made illegal in 2007. So if you're looking for accommodation and you see an advertisement notice saying no benefits, you can ignore that and apply. Tenants are entitled to rent books and details of their landlord, so that if there's a dispute, you can write to them or you can contact them. No longer can landlords hide behind estate agents and not be able to provide their own address, for example, if you decided that you wanted to take legal action against the landlord. You're also entitled to a statement of tenancy terms. In other words, your agreement with your landlord. And also, all tenants now have clear and defined responsibilities, as do landlords. In the past, there was some argument over what landlords needed to repair in a private tenancy. Legislation in 2007 clarifies that. When you walk into a private rental property, everything that was provided to you is the responsibility of the landlord to repair. Anything you brought yourself is your own. A tenant's legal obligation is to keep a property in reasonable order. A landlord's obligation is to carry out all repairs. It's also important to understand that there are different standards depending on your housing needs. If you live in a house in multiple occupation, which is a property with more than one or two households, it's important to understand that your property must be HMO registered and must have very specific fire and health and safety standards. If you have the need for housing advice, if you're an owner-occupier, if you're a renter, if you feel that you could access social housing, our colleagues at Housing Rights Service, who are extremely large and capable housing rights charity, can provide expert advice in relation to housing rights. Again, given the circumstances, they're not currently able to provide face-to-face advice, but they're able to advise via the telephone and via digital platforms. They also have an amazing website called Housing Advice NI, which very clearly sets out any housing rights and responsibilities in a very user-friendly way. Now, I know this is just a very general overview of entitlement across the UK. I would certainly invite your questions, and I would warmly invite you to contact us at Advice NI if you have specific advice needs, and we'll take the time to go through those with you. Interpretation services are also available. Thank you.
Ryan, thank you very much for a very clear and a very interesting presentation. I've already seen some questions that have arrived for you, very interesting as well, so we'll ask them at the end. Now, I would like to introduce Max Carducci, who's from Patronato, so the union ITAL-UIL, and Max is based in London. We've been collaborating very successfully with our unions in the past few years. Two Patronati, I would say in particular, that have been assisting us, ITAL-UIL and IMCA CGIL, both based in London. They offer a wide range of services and expertise to our fellow nationals, in particular in terms of pensions. So for today's presentation, I've asked Max to talk us through the services provided by ITAL-UIL, and in particular about their support with pensions, because even if the focus at the minute is clearly about the pandemic and Brexit, maybe I would say staying at home, we have some more time to catch up with some pending matters like our pension. So Max, there you go.
Thank you again. Thanks to Federica, who is organizing this webinar to give us the opportunity to reach the Italian community in a capillary way across the UK. So my name is Massimiliano Carducci, and I work for the Patronato ITAL, which is a direct emanation of the trade union UIL. Our Patronato opened 22 years ago in the UK, and I joined it in 2007. At the moment, we have more than hundreds of it scattered worldwide in the 5 continents, mainly in Europe, and thousands of offices in Italy. Our Patronato basically followed the Italian immigration post-war. And what is the Patronato? The Patronato is an institute which exercises the assistance and protection in favor of workers, pensioners mainly, and all citizens in the territory. The characteristics of the activity is to protect the individual rights on the national or foreign territory. The assistance of the Patronatos is aimed to achieve social security, health, social welfare services, including those relating to emigration and immigration. The law also provides that the Patronato can carry out support services for an Italian diplomat and consular authorities abroad. How we are found? We are founded by mainly the Ministro in Italy, together with some worker that want to donate some money to us. What I prefer is a list of common questions that we are receiving on a regular basis. For example, I've worked little time in Italy. Am I still entitled to receive a pension? Yes. If you have worked at least 1 year in Italy and you pay contribution towards your pension, you can receive a pension from this country. I did a military service. Am I still entitled to have a pension? Yes. The military service is at least 1 year or more than 1 year, and is a time where you have paid contribution in Italy, so it gives you the rights to receive a pension from Italy. I don't know how many contribution. How can I get information? We can assist you to search the contribution records in most countries in the world. I haven't worked in Italy. I haven't done the military service, but I've worked in Switzerland, Germany, France, etc., etc. The rules is the same. As long as you have worked more than 52 weeks in each country, you are entitled to a pension. So does it mean that the pension are getting together? No. Each country pay a separate pension according to the amount of contribution you have paid in that country, and they are paid in a pro rata system. Which is the age that I can get the pension? At the moment, for Italy, you are entitled for an old age pension when you reach 67 for men and female. Can I get a pension before I reach 67? Yes, you can. The past governments have did a lot of changes about pension. For example, they introduced something called quota 100 or pensione anticipata, which give you the opportunity to retire before you reach 67. So besides this kind of pension, there are other pensions. Yes, inability pension for those people that have some physical inability or mental inability, or l'assegno di invalidità for those people they have a limited amount of work, they can exercise a limited amount of work. And then there is the widow's pension, which is when the partner passed away. So what do I have to do if I have the requirements in order to obtain a pension? The bureaucracy in Italy is a little bit long and difficult to follow by yourself. We can give you free assistance, even in a remote way. Even before the coronavirus, we were using to correspond with our Italian citizen in Belfast as well, via email or via post. So coronavirus will not stop our services. Does our Patronato offer other services? Yes, of course. We can ask, for example, the Codice Fiscale on your behalf. We can give you hands to enroll yourself to the IREM, and we can give you hands to record the birth, wedding, and the death certificates. So I don't want to extend my talk too much. As we are approaching lunchtime, we might feel peckish a little bit. So I'll pass you over to the other panelists. If you have any questions, don't hesitate to ask it.
Davide, shall we go? Well, Max, thank you very much. Can I ask Davide about the questions maybe at the end? Davide, would you prefer, since we don't have that many, I think we could have time maybe to answer them all. So would you prefer maybe to ask the person to phrase the question themselves? And of course, just this is for everybody, we have Clarissa on board, who's our interpreter. So if somebody feels more confident expressing themselves in Italian, that is not a problem. And then Clarissa can translate for the panelists and translate the answer back.
Actually, we have to read ourselves the questions from the Q&A box because we're not allowed to ask directly to people also.
Okay, so we'll read the questions, and then if the question is in Italian, maybe we'll use the interpreter.
Exactly. Yes, please. Thank you.
Perfect.
Okay. So Rosella is asking, so I'm an architect employed in Belfast. If in June I go back to Italy and work from home for 2 months, do I lose 2 months for the calculation of the settlement status scheme? I would say that is something that Lumturi could answer, yeah?
Yes, so 2 months, up to 6 months if you have pre-settled status and you're planning to apply for settled status after 5 years, you are okay to go away from the UK for up to 6 months. So that should not affect your continuous residence if you're planning to apply for settled status.
So Antonella is asking, ho già ottenuto il settled status per me e per i miei figli. Cosa succederà quando rinnoveremo il passaporto? A chi dobbiamo notificare gli estremi del nuovo documento per far sì che il settled status rimanga valido?
Well, I have already obtained the settled status for me and my children. Mm-hmm. So whenever we renew the passport, what shall we do? Do we have to notify the new document details to somebody? How do we manage to keep the settled status valid? Thank you.
Mm-hmm. So as I mentioned earlier, when you get the status, it's an online status, and you get it as an attachment to your email. In that attachment, in that letter, you will also have a link that takes you straight to the point, to the section where you need to, where you update the Home Office with any changes of details on your passport or any other changes like surname or things like that. So yes, you have to make sure that you update the Home Office with any changes with regards to your passport.
Allora, sull'allegato che riceverete sulla mail c'è un link e un collegamento. Allora, quando voi fate il clic sul collegamento, vi porta sul posto del Home Office dove dovete aggiornare tutti i dati, tutti i vostri dati. Per cui sulla mail.
Sorry, can I just say, if this individual needs advice and maybe go over the steps for that, please contact us on the phone number and an advisor will take them through. Yeah.
Se vi serve aiuto per farlo, per favore, ci mettete in contatto telefonico con noi e il consigliere vi farà passo a passo, vi seguirà e così potete aggiornare i dati.
Thank you very much all. Elisa, who is asking, e se l'assenza dal paese si protraesse per oltre 6 mesi, ciò porterebbe automaticamente alla perdita del pre-settled status, oppure ritenete che possa essere considerata una causa eccezionale per cui è permessa assenza fino ai 12 mesi?
If their absence from the country is for longer than 6 months, would I lose automatically the pre-settled status, or it can be considered as an exceptional cause? So I have I would be allowed to be to be absent for up to 12 months.
So you can, if you get the pre-settled status, you can go leave UK up to 2 years and come back before that 2 years ends. But the main reason is here, the main thing that you need to remember is if you're planning to apply for settled status after 5 years, you have to be in the country for at least 6 months for every 12 months of these 5 years. So you really, if you're away for more than 6 months, unless it's very serious issue and it's to do with health or with work or you're studying abroad, you should really make sure that you come back within the 6 months. Now, sorry, I know it's too long to translate, but one more thing before I forget. You are allowed one absence of more than 6 months in the whole 5 years.
Mm-hmm.
But it cannot be more than 12 months. It should not exceed 12 months.
Sorry, Lumturi, and it's up to 2 years away. Okay.
Yes, but if you are considering to apply for settled status after 5 years, if you're away for more than 6 months, unless it's serious, it will affect that. So you're counting. Yeah.
Allora, c'è il diritto di essere fuori per 6 mesi. Allora, ci sono, da quanto ho capito io, ci sono due situazioni. La prima situazione è, se avete lo statuto di pre-settle, potete essere fuori fino a 2 anni, però se volete poi fare domanda per lo statuto di settle, non è possibile essere fuori più di 6 mesi. Se ci fosse qualche problema e ci si può stare fino a 1 anno, però soltanto una volta. Non so se si capisce.
Well, yeah, that's pretty much it. So I will move on with another question from Marcella, who was asking, as I'm up with pre-settled status and registered with my current passport document number, what should I do if I have to renew my passport, which it will have a different number, either if I am still with the pre-settled status during the passage from the pre to settled status, or once I've been registered as settled status? Should I reapply all over again? Thank you.
So if your passport needs renewed and you have pre-settled or settled status, you really don't lose your status. But you have to inform the Home Office of that change. So during this time, I wouldn't update your status. Say, for example, you have pre-settled status at the moment, and you meet the criteria for settled status in next month or so. I wouldn't worry about that, because you don't lose that status if your passport needs renewed, you can do that online via links, as I mentioned earlier. Was there anything else, sorry, there to that question?
Yeah, I would say so. So it was again, from the renewal of a new passport, what would it be affected the application for the settled status once you got the pre-settled status? So I would say that you covered it.
Okay. No, definitely. If you renew your passport, you need to update the Home Office via that link that you would have received as an attachment when you got your status. But at this stage, do not worry about updating your status. Say you have pre-settled status, simply because your passport is not renewed, say in some circumstances, I wouldn't worry at this stage. But in any way, you don't lose your status if your passport needs renewed. You just need to update them when you get the new passport.
Brilliant. So we have then another question for you, Lumturi.
Okay.
Saying my whole family, from Chiara, saying my whole family has the pre-settled status and we are eligible to apply for the settled status from the 23rd July 2020. However, one of our child, 17 years old, wants to spend a year abroad and plans leave before that date. Would this entitle her rights? Could we apply a month before having completed the 5 years of residency? Is there a time limit with which we ought to apply? Thank you very much.
Okay, so if this family meets the criteria for settled status in July, they have each one of them have been here for more than 6 months during the last 12 months. They should apply at the time when they meet, at the date that they meet that criteria, which means that from now until July is less than 6 months, and they have been in the country for more than 6 months in the last 12 months. So it shouldn't really affect their status, but they shouldn't apply before they meet that criteria. There's no, they have to be here for full 5 years before they meet the criteria, and that Home Office will grant them the status. So as it is, it sounds like they should, the individual that is going to study away should be fine as long as they have been here for the 6 months of each 12 months in the last 5 years.
Brilliant, thank you.
Okay.
We then have Fabiana saying, I have already the pre-settled status. If I go to Italy in June and I stay there for 2-3 months, can I come back to UK when I do I need to bring with me specific documents? I would say you already covered that, but...
Yes, yeah. So up to 6 months, your status is not affected, and even more than that, if you're not planning to apply for settled status. But if you are planning to stay here for a longer time and you want to settle in the country, make sure you come back before 6 months is over.
Brilliant.
Okay.
I don't know, Federica, if you want to try again with Max, so that I would say that we covered more or less all the questions regarding the settled status.
Yeah.
We can go on and check in if there is anything else. We hear you very far away. No.
But so far away, I mean, it's very, very, it's very faint.
Not at all at the moment.
Maybe, Max, you want to try and leave the call and then rejoin, if that makes any difference. Davide, would that be of some help?
Yeah,
I don't know.
Yeah, we can try that. All right. So I would say we can go on with the questions then. Let's see. So one is asking in Italian, Luisa Ramazzotti. Sono residente in Scozia dal 1974, mia figlia è nata in Scozia nel 1986. Mi è stato detto che può ottenere il passaporto UK invece di fare la richiesta del settled status. Clarissa, if you want to provide a translation. I'm afraid you're mute at the moment. Here you go.
So I'm sorry, I'm resident in Scotland since 1976. My daughter was born in 1984 in Scotland. I was told that I can apply for British citizenship instead of directly instead of going through the settled status.
I don't know if Lumturi, you want to answer the question?
Can you hear me now?
Yes.
Yes.
Yeah. So to apply for British citizenship, one of the requirements is if say you have permanent right to reside, you can, and you've held it for a year, you could apply for British citizenship before end of December. But if you're applying for settled status, you definitely have to hold it for 1 year before you apply for British citizenship. Now, having either of these statuses doesn't mean that you meet the criteria for British citizenship. That's only one of the requirements. So there are a list of other requirements that you need to meet for getting the British citizenship. I would advise that whoever is the person who is thinking to do that actually get some advice before you do it if you're not sure, because if you make the application and you're refused, you don't get compensation back. You don't get that. The fee is quite high, over £1,000 for that application. So just make sure you do everything in order and get advice before you make that application.
Allora, voi potete avere sia il diritto di residenza che lo statuto di pre-settled per un anno prima di fare domanda alla cittadinanza britannica. Comunque, se avete dei dubbi, sarebbe il caso di... c'è un lungo elenco di cose che occorrono per diventare britannici, per cui siccome costa tanto sarebbe il caso di chiedere a un consigliere autorizzato o qualcuno che sa, che se ne intenda, perché i soldi non vengono restituiti se siete respinti.
Brilliant, thank you.
Can I just add there, just because this is outside, can I just add a little bit, because this is outside EU settlement advice. Definitely I would advise a person to get advice from somebody who is qualified on that area on British citizenship and before they make the applications, so they make sure, yeah.
Siccome questo è un po' fuori dal nostro remito, io vi consiglierei di mettervi in contatto con qualcuno che abbia le qualifiche per consigliarvi sulla cittadinanza britannica.
Brilliant.
Thank you.
Thank you. Then we have, so what if I have a pre-settled status and go abroad for more than 6 months for work reasons? Do I lose my status?
No, so yes, so you can go away for more than 6 months for working or studying there. The only thing you always have to remember is if you're staying anywhere for more than 6 months and you're planning to apply for settled status after 5 years, that might jeopardize your continuous residence. So and I will just specify again what the continuous residence is. For you to get the settled status, you have to be living in the country for 5 years continuously, meaning that you have to be in the country for more than 6 months in each 12 months in the last 5 years. If you're away for more than 6 months, unless there's serious reasons about it, and we will share that, I can share that the list of the reasons there. So unless it's very serious, like a childbirth or illness or compulsory military service, that is for any time actually. Unless it's very serious, then and you can provide evidence about that seriousness, you will break that continuous residence.
With COVID-19, we have heard of stories of EU citizens that have been evicted due to fear of bringing the virus. How could people get help if they don't know their rights? I don't know if maybe Ryan want to answer that.
Certainly. If you have a tenancy agreement with the landlord, you cannot be evicted unless you have breached the terms of that tenancy. And even in a situation where there is a breach, unless there's a court order to remove somebody from a property, nothing can be done. In terms of protection from illegal eviction and harassment, the local councils, environmental health authorities are licensed to police this. So if somebody's being asked to leave a property for no reason whatsoever, and the reason in your question simply isn't good enough, if it's not a breach of a tenancy, you must be able to stay there. And a call to the environmental health department of your local council will ensure that that landlord takes no further action. The environmental health department can prosecute landlords for illegal eviction and harassment and do so regularly.
Brilliant. Thank you very much, Ryan. So we have another long question. So Monica is...
Yeah, the one from Monica,
yes,
if
exactly.
possible, Davide.
Yes. So my question is about COVID-19 lockdown and renting house, not housing as I'm paying my rent as always have. Despite this, my landlady keep asking to leave the house and looking for another room. Please note that I have always complied with my duties. The contract is just a share house agreement. It look like, according to the new law, I've got no rights at all. My question is, can my landlady, despite the lockdown, make me forced to leave the house? It is very difficult looking for another house now, and it is also dangerous because of the COVID-19. I hope you can help me. If not, I hope you can tell me to whom should I ask for my advice. In any case, many thanks for your attention. Kind regards, Monica. Ryan.
Quite similar to the last question, if you have a tenancy agreement and it has not run out, nobody can ask you to leave a property. A tenancy agreement is like a contract between you and your landlord. If your tenancy agreement is for a year and you still have, for example, 6 months on it, you're there for the entirety of that time. If there is no tenancy agreement, the law assumes at least 6 months. If the tenancy agreement has finished, at the very least, you're entitled to at least 1 month's notice before you have to leave. The organization known as Housing Rights Service would be able to provide advice in relation to that. But the message is very clear. If you have not breached your tenancy terms and you have a lease, you're entitled to remain in that property for the duration of the lease.
Thanks, Ryan. Following this one up, it is asked, what if there is no tenancy agreement, but if there is just a lodge agreement? I have been told that for house share agreement, it is different if it is like we have got no rights. Thanks again.
It's actually illegal not to have what's called a statement of tenancy terms. Every tenancy by law has to have a statement of tenancy terms. If there is no statement, the law assumes an automatic 6-month tenancy. So in a situation like that, where someone's being told that they have no rights or no right to an agreement, reporting that to the local council, environmental health authorities, will also provide relief in that situation, because they can insist that an agreement is put in place and that the tenant's not evicted illegally. Also, the Department for Communities, who have some responsibility from central government for housing, have also issued advice to tenants who have come to the end of their lease. And the advice that they've issued to both landlords who are registered with the Department for Communities and tenants is, if your lease has finished, you should not leave the property. You should remain in the property and only look for more housing when this crisis has finished. So there's very strong coverage for this at the moment.
Brilliant. Thank you, Ryan. I would just go...
And perhaps this is a little bit naughty. Our courts are currently not working. The court service in Northern Ireland only deals with emergency cases, usually of a criminal nature. For a landlord to remove you from a property, they require a court order. To get a court order, you need a court to be open. We don't have that right now. So as long as you're paying your rent, I think your landlord will have to take the view that you're staying there.
Thanks, Ryan. Thanks for that. I just go back to one that we asked before, but we do not have enough details. So Francesca is saying, I live in Belfast with my partner. He's a British citizen, and we are going to get married next February. I have the pre-settled status. What is going to happen with the marriage? Do I have to apply anyway for the settled status? So Lumturi, if you don't mind, back to you.
Yes, so in that case, yes, still make your application for every EU national. Everyone has to apply for either settled or pre-settled status, whatever the criteria they meet. So even if you're married or you're getting married or you've been here from before 1972, we also advise people to make the application. So yes, definitely you need to make that application.
All right, thank you.
Excellent. So I think our time is up for today, and I would like to thank very much all our guests, again, all the panelists and everybody who has joined us from home. I hope this has been helpful for you. And again, as we said, you'll find the recording online soon. So thank you very much again, and have a lovely weekend.
Thank you. Bye.
Thank you. Thank you. Bye-bye.
Bye-bye. Thank you.